respect to oral evidence. But the rest of the affidavits that have been exchanged, where the parties are either at idem, would not have to be canvassed again. It's like your typical situation of having an application and a referral to oral evidence only once one determines which material disputes of fact there actually are that cannot be resolved on the papers.
Yes.
Isn't that a process that would be in the interest of justice, because it'll be a speedy and an expeditious way of resolving this question of whether there are grounds to say that Mr. Dana lacks the title to prosecute?
Yes. Excuse me. Yes, my lord. No, that I understand. But with the greatest respect, my lord, that's got really nothing to do with the issues of today. Remember, your lordship is quite correct that your lordship sanctioned, for lack of a better word, that procedure. And your lordship was within your lordship's rights to do so. But remember, my lord, that even in civil proceedings, a postponement is asked for when something intervenes that was unforeseen or unforeseeable, right? So that's where we are now. The fact that your lordship sometime in May put a particular procedure in place is neither here nor there. Because everyone, including your lordship and us and even the other side, at that time, the last thing you had in mind when your lordship sanctioned that proceedings was that procedure would be done in the absence of the accused. That is the intervening fact that was unknown to either your lordship or to any party at the time. Secondly, the lordship could not have known that 2 months later there'll be some unrest which will necessitate that proceedings in court should be dealt with in a particular way or not in a particular way. There's nobody, none of us were sangomas that could have foreseen something like that. Thirdly, your lordship could also not have foreseen that come the hearing of that procedure, there will be conditions which make it difficult for the accused person to consult with his legal practitioners, such as the prevailing conditions. All those things, my lord, are the things. So the fact that your lordship sanctioned a particular procedure, as they say in economics, all things being equal, has got nothing to do with the current situation where the things are not equal in respect of all those three things. We all postulated at that point a public hearing. We postulated the presence of the accused. We postulated proper opportunity to consult. So that can never be used now to deal with the current situation where the Section 35(3) rights, which were assumed when your lordship made the ruling in May, have now disappeared. That's the whole point. That's exactly why we're here. So the one cannot. Then, my lord, in respect of the, I'm sorry, let me just finish that point. So that's where the interest of justice. So if someone had said to your lordship in May, but is this process in the interest of justice? The answer, at least that I would have given, is yes, it is, because it assumes all these things. But if you ask me now, on the 19th of July, whether it is in the interest of justice when it is now going to happen in the absence of the accused, without his having had proper consultation and so on, then obviously the answer is different, because none of us could know. We're not soothsayers who could have known that these positions happen, which is why, as your lordship knows, postponements are even granted literally without an application. If on the way to court, the accused is knocked by a car or something, one cannot say, no, but we put this date because those unforeseen circumstances would then happen. And the lawyer would say, well, my Lord, as we were driving here, the person was knocked by a car, so we need a postponement for that reason, not for the reason of what was taking place when the postponement was granted.
Yes.
Yeah. Thank you, my Lord. The last point related to this, my Lord, is this. It would be, in my respectful submission, even if we were having a normal 106(1)H process without this issue about oral evidence, still, my Lord, 108 would apply, because 108 doesn't say which plea. It simply says any plea other than a plea of guilty. So we're certainly in that zone. And any plea other than a plea of guilty needs to be tried, which means we are in the trial situation. In fact, even your Lordship will remember that most of the sections there exclude a plea of jurisdiction. But here, even a plea of jurisdiction would be covered. Any plea other than a plea of guilty means that we're in the trial zone. But more so here, my Lord, where the issue of oral evidence has been specifically raised. So your Lordship could not possibly preempt the outcome of the oral evidence application. Because if your Lordship said, no, Mr. Mpofu, this one is merely on the papers, by saying that you'll already be preempting the outcome of the issue which we have raised, which your Lordship is not empowered to do, because you cannot know.
I'm not saying that. I'm not saying that, Mr. Mpofu. Sorry, I'm not saying that.
No. I accept, my Lord. I'm saying, I accept. Sorry, my Lord.
All I'm saying is the parties chose, and it had my sanction, that the issue raised by the special plea be dealt with by way of affidavit. It's a recognized procedure, we can deal with it on affidavit, and all I was saying is that the need for oral evidence would only arise if there's a material issue arising from the affidavits, comparing or analyzing the affidavits, that there's a material issue on which there's a real dispute of fact, and then that narrow point will be referred for the hearing of oral evidence. It doesn't contemplate a fully blown, for want of a better word, fully blown trial. And when 108 talks of tried, that could be even until the end of the trial. It could be the end of the trial.
Yes.
Whereas,
I understand, my Lord.
You wanted, and I think probably correctly so, you and Mr. Zuma, obviously, wanted this 106(1)H issue to be resolved, to be tried, if you like, up front, because your view is that, or your submission is, that if it succeeds, then in terms of 106(4), he's entitled to an acquittal. And then there's no need for the rest of the trial and all the evidence on whatever payments might or might not have been made, etc. Because otherwise tried, it could be, he's entitled to demand it, that it be tried, but that could be the issue stands over until right at the end.
Well, my Lord, with respect, no, I disagree with your Lordship's analysis. Firstly, by introducing the 108 issue, maybe we were introducing under I don't know, maybe we didn't articulate it properly in the reply or in the heads, but we are introducing it as follows, my Lord. We are saying that per se, by definition, the 106(1)H proceedings must happen by way of trial proceedings or with oral evidence, because of the provisions of Section 108 of the Criminal Procedure Act. We may be right or may be wrong about that proposition, but that's what we're saying. We're saying that section prescribes that the procedure must include viva voce evidence. Now, that's the point I'm making. If we're right on that, about that proposition, then the entire thing must be done by way of evidence. In other words, what we should be doing today is to call our first witness and so on and so on. And as I say, we may be wrong about that. But that's not the point. The point is that your Lordship is not in a position now to preempt whether we are right or wrong. For now, your Lordship has a dispute at best as to whether this process should be done by way of viva voce evidence by definition, or only on the limited basis that your Lordship is talking about, which is the normal plus con Evans type of situation, or Rule 65G, where if there's a dispute, it can be referred to oral evidence. That's not where we are. We're not in that Rule 65G area. We're saying by definition 108 prescribes that the proceedings should be done by way of viva voce evidence. And as I say, that may or may not be a good legal point. But nobody can deny that 108 says that the issue must be tried. And if tried means what we all know it means, then it must mean viva voce evidence. And if we are correct about that, then and I was not saying that your Lordship says this, but the NPA at least says that it should be no problem with this virtual hearing, because in any event, this is just argument on paper. But we're saying that is not God-given, that it will just be argument on paper, because that issue about the implications of 108 will still have to be determined. That's really the submission. But we'll go further by saying, my Lord, that even if there wasn't an issue of viva voce evidence, the point of the matter is that we are now in the trial proper, and the accused person is entitled to a public trial in his presence. And we go further to say it's even worse if he has not had an opportunity to consult. Because, my Lord, let's forget about the legalities now. Let's look at it practically. We are saying to your Lordship, because of these intervening circumstances, we have not even been able to consult on this issue of the 1061H. I can tell your Lordship from the bar that actually we were consulting on the 28th of June. We were busy consulting on this matter. And then the following day, the Constitutional Court judgment came, and therefore we were all busy with dealing with that matter. So, and then your Lordship made a good proposal last week that it would be prudent to postpone this matter. And that's why we take exception to Mr. Downer's suggestion that this is a delaying tactic. Because if it was a delaying tactic, then it would have come from the accused person. This proposal came from his Lordship. And this proposal also came from the Judge President, who asked for matters to be postponed this week. And nobody can accuse the Judge President or his Lordship of delaying tactics. These were done on the basis of the prevailing circumstances, unforeseen, unforeseeable circumstances. All those proposals, we accept they were done in good faith by your Lordship and by the Judge President to deal with the current situation. All we did, and your Lordship will see in the correspondence, was to agree with your Lordship. We said we agree that it is a prudent way to deal with this, and now we're being accused of so-called delaying tactics, which is really uncalled for. The point, I'm sorry, Malan.
Yeah, I'm not sure that, I don't think you have to be concerned about that. I'm going to deal with this matter on the legalities that arise. All I want to say about the week's postponement is it has become one where I'm obliged to have said it is prudent that it be adjourned. That is not what I said.
Yes.
If my email is as an annexure to the papers, and I said it might be prudent, and it was said in the context that I had mooted the possibility of a virtual hearing, and I said I would need to gain access to the IT officials to arrange it, And because of the unrest in prevailing in Peter Maritzburg, I couldn't get access to the court. And it's in that context that I meant it might be prudent. But then things change thereafter.
Well,
but anyhow,
that's the point. That's the problem. Your Lordship did say it would even be prudent to consider adjourning the hearing for a week, depending on the availability of all counsel, until the present problems might hopefully be abated. We don't put it higher than that. All we're saying is that...
In some of the affidavits, it said that I said it is prudent. I said it might be.
Might, I can live with might. That's good enough. If it was put higher than that, my Lord, then we apologize. But let's deal with what it says here. Your Lordship says it might even be prudent to consider adjourning the hearing for a week, depending on the availability of all counsel. The point, I'm making two simple points. That the first person to even talk about an adjournment was Your Lordship. And what we did, and we accept that Your Lordship did so not for any other purpose, but to deal with the current situation. All I'm saying, my Lord, about that is that once this happened, as a matter of reality, we wrote to Your Lordship and said, today we are going to consult with the client. We went to consult with the client. We discussed this letter. We even left copies of Your Lordship's letter with the client to say where it says it might be prudent to consider an adjournment. And Your Lordship then says things changed. The only things that changed is that the following day, the NPA was of a different view, that it might no longer be prudent. And we have not had a chance to discuss that new prudence with the client. The client knows that Your Lordship said it might be prudent to adjourn, and the client agreed. We even said in the unlikely event that the client gives us different instructions not to agree with this approach, then we will communicate to Your Lordship. And we didn't communicate, so you can assume that our instructions were consonant with the proposed postponement. And that's the reality of the situation. So the proposed postponement was really and that's why we supported it for a week or two to look into the situation, and then maybe some other practical arrangements could be found. You never know. Maybe the client might even be out of jail by then. Nobody knows. If a couple of weeks, the situation might change. All these debates about the presence and absence might be of academic importance. But as we sit now, my Lord, it cannot be denied that he is handicapped, or his rights in terms of 35(3) are violated or limited, to put it mildly.
I think in the light of the relief that you're claiming for a declaratory order, the position must be assessed as it exists now. We can't speculate on what might happen in 2 weeks' time, or even a week's time.
No, but then Your Lordship is changing that. Well, that can't be correct, my Lord. If Your Lordship says it might even be prudent to consider adjourning the hearing for a week, depending on availability of counsel, until the present problems might hopefully be abated, then Your Lordship was speculating. We don't that in 2 weeks' time the present problems might be abated. I'm simply saying that those problems, it's inevitable. When you postpone a matter, you are projecting into the future. Your would not have been said for a week that in that might be. So we can now say, let's not speculate. We are speculating the mere fact of postponing for a week or so. You might get. That's the nature of the exercise. That's what Your Lordship's words indicate. Because if in a week the situation got worse, then Your Lordship would obviously say, well, the situation has gotten worse. But if in a week or two the situation got worse, or rather better, then we would deal with that. So speculation cannot be excluded.
Yeah, all I'm saying, Mr. Mpofu, is really that...
I'm merely saying that speculation might even include a situation. We know that there's an outstanding judgment in the Constitutional Court. I'm saying we might all be out of this by the fact that all these issues might not apply, just as the security or unrest situation might have improved.
Yes.
At least from our point of view, that would be the reason of a couple of weeks postponement.
What is the length of the postponement that you're asking for?
My Lord, we on the basis of if we follow your Lordship's logic, you remember your Lordship said a week, and we said a week or two. I would say if your Lordship is going to factor in the possibility that I've just mentioned of the Constitutional Court judgment being out by then, I would say not more than 3 weeks, 2 to 3 weeks. I expect that court to given the history of how it has dealt with the matter, to prioritize that judgment. And so we don't know, obviously, as your Lordship knows, but we expect that judgment to be out in the next 2 to 3 weeks or so. Yeah. And then all these problems would be resolved by just the stroke of a pen, and then we'll be back to exactly where we were when your Lordship gave the order in May.
Yes. Yes, Mr. Mpofu, the possibility of adjournment that I'm mooted, I don't think we need to debate it further, but I just obviously point out that it should be in the context of that whole email.
Yes.
And particularly the statement made at the end of the paragraph, just preceding that paragraph. But as I say, I don't think it takes the present debate much further. Anyhow, yes, any further submissions?
No, my Lord. Those are our submissions, my Lord. We therefore would employ your Lordship firstly to, well, either to grant both orders, or if your Lordship is inclined to only grant the declarator, as we say, that the postponement would almost follow automatically, but would leave the period to your Lordship's discretion.
Yes, thank you. It's past 11. Should we take a short postponement now for 15 minutes, also as a comfort break? And if you require Mr. Mpofu to speak to Mr. Zuma, I confirmed this morning that he has a facility available in the correctional facility at Escort, a phone that he can use that if he needs to speak to you. But it seems to me this is a matter that's been on affidavit. But I make that offer to you. That's the long and the short of it.
No, thank you, my Lord. No, thank you, my Lord. Apropos that, yes, my Lord. Well, firstly, we are indebted to your Lordship for having accepted the affidavit from the attorney. Obviously, ideally, it would have had to come from the client, but because of the current situation, the affidavit only came from the attorney. Secondly, we were certainly not aware that we would be able to consult, but we're indebted to your Lordship. We will use whatever facilities. I don't know whether it's by Teams or by telephone, but
well, perhaps you can just make inquiries in that regard, what should happen. That is, if he needs to speak to you.
Yes. Well, I'm sure he does, man.
Well,
well, at least I want to speak to him.
Yes, no, that's fine. But what I mean is that whether there's specific instructions, because this matter's been argued on the papers, on affidavits, you confine to the affidavit, or the affidavits, and that's the basis upon which it will be decided. So the scope for instruction is really limited, but I don't say it. I don't take it any further than that.
Thank you, my Lord. I understand.
I take it, Mr. Trengrove, if you're happy that we take the adjournment now, and then you can start when we hopefully resume at, I make it now 11:15. Shall we say 11:30?
Thank you.
We're all back. We listen to you, Mr. Trengrove.
Thank you, my Lord.
Thank you. can hear us, Mr. Roo. Thank you, my lord. Thank you. Yes, Mr. Trengo, you may proceed then. If I may just preempt what you're going to say. Obviously, I would appreciate you dealing with the issue of whether I can grant the declaratory relief in paragraph 1. That's the one issue. The other one is the question that was raised about alleged violation of section 35(3)(f) rights, because that wasn't sort of made prominent in the papers. And in the third issue, I suppose the objection to the argument on the special plea being heard virtually, because Mr. Zuma says he wants to give evidence during that special plea.
Thank you, my lord. I'll certainly address those 3 questions.
Thank you.
May I suggest at the outset that it is clear we're not going to hear oral evidence today. We also accept that if you were to hold that it is necessary to hear oral evidence to determine the special plea. By special plea, I mean the defense under section 106(1)(h). If you were to hold that it is necessary to hear oral evidence to determine that defense, then that will obviously not be done today, and then we will have to reconsider the appropriate process by which that evidence should be heard. It might be done virtually, but a more elaborate arrangement would then have to be made. So for the moment, we're not debating and we're not suggesting that the arrangements, the current arrangements, are suitable for oral evidence and that you should proceed to hear oral evidence. We will submit, on the contrary, that oral evidence is not necessary or justified for the determination of the special defense. That is so for 3 reasons. Firstly, because it's bad in law. The facts advanced in support of the special defense simply do not sustain such a defense. We'll call it excipiable. I know that's the language of civil law, but by analogy, we'll say that the plea is excipiable. We submit in the second place that there is, in any event, there are no material disputes of fact, and therefore there is nothing to be resolved by oral evidence. We submit thirdly that in any event, most of these issues have been decided by the Supreme Court of Appeal in the Spite Tapes judgment and by the full bench of this court in its dismissal of Mr. Zuma's application for a permanent stay. So that the special defense can and should be determined today because no oral evidence is necessary for its determination. And we submit that because this debate is merely a debate on the paper before the court, it is entirely legitimate and lawful to have this debate on a virtual platform. And we will address that at the outset as a defined issue. So that we proceed on the basis that if you were to find that oral evidence is necessary, then we'll have to have that process on another day. For the moment, we seek to persuade you that oral evidence is not necessary or admissible in support of the special defense, and therefore there's no need for a postponement because the matter can be debated and determined today. I'm going to address a few general issues which is relevant to the general context in which these issues arise, and then address the following topics. I shall address firstly the lawful competence of a virtual hearing for purposes of today's debate. I will then have a look at Mr. Zuma's affidavits to see what it is that he wants when he says he wants a referral to oral evidence, because he doesn't ask for an opportunity to give evidence at all What he asked for is for Mr. Downer and various state officials to be called up for interrogation. And we will submit that there is just no basis for that at all. I will then submit that the special plea is acceptable on the grounds upon which Mr. Zuma seeks to advance the special defense. In other words, even if one were to accept all of his evidence, the defense is in any event bad. And lastly, submit that there are no material disputes of fact in any event, so that there is no point referring anything to oral evidence. May I start off then just with one or two topics of general context. The first is that it's important to bear in mind that there is a duty on the state to prosecute corruption, and in particular to prosecute public officials accused of corruption. And it is not merely part of the general duty of the state to prosecute crime. It is a particular duty imposed on the state by both the Constitution and under international law to prosecute corruption. Firstly, as for the duty under the Constitution, this was a matter that the Constitutional Court considered in Glenister's case. And that is Glenister v. President of the RSA, 2011, 3 SA 347, judgment of the Constitutional Court. The court, Glenister in the first place, in paragraph 172, endorsed a statement it had earlier made in the case of Heath, where the following was said about the scourge of corruption. Corruption and maladministration are inconsistent with the rule of law and the fundamental values of our Constitution. They undermine the constitutional commitment to human dignity, the achievement of equality, and the advancement of human rights and freedoms. They are the antithesis of an open, accountable, democratic government required by the Constitution. If allowed to go unchecked and unpunished, they will pose serious threat to our democratic state. And for that reason, the Constitutional Court went on in Glenister to say that the Bill of Rights imposes a duty on the state to combat corruption. It did so in paragraph 177 as follows. The state's obligation to respect, protect, promote, and fulfill the rights in the Bill of Rights, thus inevitably, in the modern state, creates a duty to create efficient anti-corruption mechanisms. Parliament has recognized this in the preamble to PRECA. All this constitutes uncontested public and legislative policy in South Africa, for it has been expressly articulated and enacted by Parliament. That's the duty under the Bill of Rights, but there's also a duty under international law, also discussed in Glenister. Glenister said in paragraph 178, our Constitution takes into its very heart obligations to which the Republic, through the solemn resolution of Parliament, has acceded, and which are binding on the Republic in international law, and makes them the measure of the state's conduct in fulfilling its obligations in relation to the Bill of Rights. That must be read with the provisions of the United Nations Convention Against Corruption, UNCAG. The United Nations Convention Against Corruption imposes a range of duties on all states party to the convention, which includes South Africa. But the one that is particularly relevant to this case is the duty that it imposed on the prosecution services of the treaty parties. And that is in Article 30, sub 3, which reads as follows. Each state party shall endeavour to ensure that any discretionary legal powers under its domestic law relating to the prosecution of persons for offences established in accordance with the Convention are exercised to maximize the effectiveness of law enforcement measures in respect of those offences and with due regard to the need to deter the commission of such offences. So that is important because it guides not only the context in which the proceedings today are held, but guided and was meant to guide the prosecution of this case. And that is that the discretionary powers must be exercised to maximize the effectiveness of law enforcement. Now, Mr. Zuma's invokes his right to a fair trial under Section 35(3) of the Constitution. And that is undoubtedly a right to which he's entitled, and an important right which we should all be careful to respect. But it must also be understood that the right to a fair trial under Section 35(3) is not a one-way street. And the Constitutional Court has made that plain on more than one occasion. It's made the point in Sheikh's case, that's S.V. Sheikh, 2008, Volume 2, S.A. 208, paragraph 43, where it said the following: the right to a fair trial requires a substantive rather than a formal or textual approach. It is clear also that fairness is not a one-way street, conferring an unlimited right on an accused to demand the most favorable possible treatment. A fair trial also requires fairness to the public as represented by the state. It has to instill confidence in the criminal justice system, with the public, including those close to the accused, as well as those distressed by the audacity and horror of crime. That same sentiment was reiterated later in a case of Estate Agency Affairs Board v. Auction Alliance, 2014, Volume 3, SA, 106, Constitutional Court, in paragraph 71, where Justice Cameron, for unanimous court, endorsed the proposition that the right to a fair trial is not a one-way street, it cuts both ways, and then added the following, particularly apposite to a case of this kind. The fair trial right does not mean a predilection for technical niceties and ingenious legal stratagems, or to encourage preliminary litigation. A pervasive feature of white-collar crime cases in this country. To the contrary, courts should, within the confines of fairness, actively discourage preliminary litigation. Courts should further be aware that persons facing serious charges, and especially minimum sentences, have little inclination to cooperate in a process that may lead to their conviction, and any new procedure can offer opportunities capable of exploitation to obstruct and delay. And then it added, one can add the tendency of such accused, instead of confronting the charge, of attacking the prosecution. Well, this is such a case. The accused has for more than 10 years taken every point in the book to avoid having his day in court. He desperately seeks to avoid answering the charges of corruption, fraud, and money laundering made against him. He raises objections again and again. The objections raised today are objections which were raised and decided against him by the Supreme Court of Appeal in the spy tapes case and by the full bench in the stay of prosecution. You will have seen the analysis included in our answer to the application for a postponement, that 135 paragraphs of his heads of argument in this case, in support of the special defense, are paragraphs cut and paste from his application for leave to appeal to the Constitutional Court against the full court judgment. It merely illustrates two things. Firstly, that this is simply a rehash of old complaints dressed up as a special defense under section 106(1)(h). But it is merely a ruse. It is a recycling of old complaints. The second is that these self-same complaints are the very complaints which he abandoned, when he abandoned his application for leave to appeal to the Constitutional Court. In other words, it is these are contentions in which the accused himself had given up any hope when he abandoned his application for leave to appeal to the Constitutional Court. And we submit with respect that it's an abuse to rerun the same complaints again, this time under a guise of section 106(1)(h). Now, so much for the general background. Let me turn then to the competence of a virtual hearing. And let me say at the outset, my lord, that I agree with my learned friend with respect, that there is no obstacle to your determination of the issue in the light of your earlier directive. Firstly, at a technical level, your directive was a purely interlocutory direction and no more. And it is in the nature of interlocutory directions that the judicial officer who issues them may reconsider them again and again and again. There's no irregularity in that context. So I agree with my learned friend that it's open to you to consider the issue afresh. But the prayer, in any event, the application, the first prayer for a declarator in their postponement application is that the trial of the accused plea on a vertical platform would be unlawful. That's the trial. And the whole theme of their application is that it would be unlawful because oral evidence can't be appropriately determined on the virtual platform. So, and for the moment, that is not the issue. We're not going to seek to persuade you today to take oral evidence on a virtual platform. That is a debate for another day. What we are seeking to persuade you is that a virtual platform is legitimate and lawful and appropriate for the determination of the special defense, because it may be determined without the hearing of oral evidence. And there we don't need to go back further than the directions issued by the Minister of Justice, which have been annexed to our answer to the postponement application. If I may ask you to go to those directions, it's Annexure A11 to our answer. The papers haven't been paginated. It is my page 45, but there is no pagination. If I may refer in that application, because my learned friend suggested that it does not explicitly cater for a debate of the kind we're having today. But with respect, in the first place, paragraph 10 says an audio-visual link may be used for a bail application and any other process deemed appropriate by the judicial officer. It can't be clearer. Any other process deemed appropriate. So it merely depends on your judgment as to whether it is appropriate. The same goes for paragraph 14. Audio-visual links may be used in any proceedings where the presiding officer deems it appropriate, and if to do so will prevent unreasonable delay, save costs, or be convenient, and makes it unnecessary for the person to appear in person in the courtroom. We're spot on.
But now Mr. Mpofu says that is not for criminal proceedings.
Well, he just says so, but it is. It is for all proceedings. It doesn't make any distinction between categories of proceedings at all. There are other provisions which cater for different types of proceedings, but these are and are meant to be general rules. And may I just add to that paragraph 15. Every court must strive to function optimally. That's a duty imposed on the courts. And the fact that these rules cater for criminal cases as well is evident from paragraph 17, which requires cases to be placed on a priority roll. And if you look at 17b, cases where the accused person are charged with the following, and then sub 4 is corruption. So it deals with criminal cases, and what's more, deals specifically with corruption cases. And then in C, cases that are trial ready, that's us. And in G, any other case in which the presiding officer, etc. So not only is it competent, but these are cases that must be placed on a priority roll for determination in accordance with these directions. Now, a learned friend then says, well, but the Minister of Justice cannot detract from the Constitution. And therefore, I don't know what, therefore what, you must ignore his directions. But in the first place, you can't just ignore any legislation. As you know, my lord, under the Odekral principle, and adopted by the SCA, and the Curlin principle adopted by the Constitutional Court, administrative action, which includes subordinate legislation, stands and must be respected and obeyed and applied until reviewed and set aside. So it doesn't help merely to say that these rules are in conflict with the Constitution. But in second place, they are not in conflict with the Constitution, and the SCA has indeed held that to be so in De Beers case. Now, my lord, I don't know whether your lordship has a copy of De Beers case. A copy has been included in a supplementary bundle,
yes,
which has been distributed. But if we will refer particularly to paragraphs, so let me say, the SCA considered in De Beers case whether it was competent to have a hearing of an appeal on a virtual platform. And it discussed the matter quite comprehensively from paragraphs 32 to 71. But I'd like to emphasize paragraphs 64 to 67 because they there addressed and dismissed the very contentions advanced on Mr. Zuma's behalf based on the Constitution. Because the court said in paragraph 64, that was of course a civil case, but the court said the Constitution in terms of section 34 gives everyone the right to have any dispute that can be resolved by application of law decided in a fair public hearing before a court. Section 91A of the Supreme Court Act requires that all superior courts must be open to the public. Mr. De Beer and his organization, LFN, did not provide any basis as to why convening the oral hearing of this appeal on a virtual platform to which the public enjoyed access was not a fair public hearing. It elaborated on it in the rest of paragraph 64, but then towards the end of the paragraph said the following. Absent special circumstances, proceedings are no less open because they take place on a virtual platform. Indeed, such proceedings may be more accessible to the public and no less open to the parties. As indicated above, the directives issued by the Chief Justice and the President of this court, having been agreed by the heads of court, although premised on the national state of disaster, were founded on the power of the judicial authority provided for in sections 165 and 173 of the Constitution and sections 8.3 and 8.4 of the Supreme Court Act. This was done to deal with the prevailing circumstances and to preserve and advance open justice. The alternative would be for the administration of justice to grind to a halt. So my learned friend is, with respect, quite wrong to say that the directives of this kind may not be issued by you under Section 173. The Supreme Court of Appeal expressly recognized the legitimacy of arrangements of this kind under Section 173. And then in paragraph 65, the court said the following: if the virtual hearing proposed to the parties give rise to infringement of their right to a fair, open and public hearing, then it was open to this court to regulate its own process. A party cannot dictate how the proceedings will be conducted. That is a matter for the court to determine. Nor may a party use its failure to secure the form of proceedings it favors as a tendentious basis for claiming that the court may not adjudicate the merits of the matter, much less level the unwarranted accusation that the court is biased. So the court held not only that it was competent to, under Section 173, to direct that a virtual hearing be held, but also that such a hearing satisfies the constitutional requirements of fairness. So it is not even a limitation which is justified. There is no limitation to start off with because it is a fair public hearing, and no less fair and no less public than it would have been in a courtroom. Our learned friend relies on 3 paragraphs of Section 35.3, but they, with respect, don't take them any further at all. I won't even raise any objection to their reliance on F, because my learned friend accepts that if they don't come home on C and E, then F won't do it for them either. But the hearing of this debate on a virtual platform is a public hearing to which the public have access. And in the presence of the accused, he is present on the platform, a la De Beer. So that, with respect, it is a competent mechanism, it is an appropriate mechanism, and it is one that the court is not merely entitled, but with respect, obliged to adopt in the exercise of its discretionary powers to ensure that fairness is done, not only to the accused, but also to the public interest in the prosecution of, particularly in the prosecution of any serious crime, but particularly in the prosecution of corruption, fraud, and money laundering. So we submit that the process is a lawful and competent one. Let me then turn to our submission that the request or demand for oral evidence is unfounded and unnecessary.
Just before you go there, Mr. Trengove, Mr. Mpofu's criticism of a reliance on Section 173 was that those 3 exceptions created in the Criminal Procedure Act provide with exhaustively with the situations where a criminal trial, as opposed to a civil appeal, as in De Beer, but a criminal trial, and where an accused wouldn't be required or can be excused from attendance. And he says, well, if you can't bring it under those categories, then this residual sort of power that's open in terms of 173 applies to the civil law, but not to criminal law.
Lord, yes, but the fallacy in that contention is the suggestion that anything is being decided in Mr. Zuma's absence. Mr. Zuma is present in this hearing as much as any one of us. So there is no question of his exclusion from the hearing. He is present and he can participate in it as much as he would have been able to do in an actual court hearing. And both provisions on which the accused relies, section 158.1, as well as section 161.1, the one providing for the presence of the accused, is subject to any other law. It expressly says so. And certainly the directions of the Minister of Justice is another law which expressly allows for this process. So that, firstly, there is no departure from the rules laid down in those sections, because on a virtual platform, the accused is present. And secondly, even if there is a departure, it's a departure permitted by the very provisions themselves, which yield to any other law. But, my Lord, it is then important to consider what it is that the accused wants. Because this notion that he wants to give evidence is, with respect, not a true reflection of the case he's made. And may I take you through his pleadings very briefly to identify what it is that he says he wants oral evidence on. I'll start with his plea, with a formal plea itself. That's on page 1 of the court record, the paginated court record.
Yes.
He says in paragraph 1,
thank you.
There are facts and circumstances involving the conduct of Mr. Downer from conducting a fair prosecution. Oh, sorry, I've just missed a page. I have a page missing. But he says that. Oh, sorry, I read the wrong paragraph. It is paragraph 1, but it's the previous sentence. I give notice of my intention to raise a further plea in terms of section 106.1h, that for reasons that are set out in the plea explanation, Mr. Downer SC should be removed as the prosecutor in this case, as he has no title to prosecute. So that is his opening definition of his special plea. He then goes on in his plea explanation to elaborate on that complaint. If I may ask you to go to the following parts of his plea explanation. He says on page 6 in paragraph 4, I intend to plead that Mr. Downer has no title to prosecute. This I say because there are facts and circumstances that demonstrate that he lacks the independence and impartiality to prosecute. Paragraph 5, consequently his retention as prosecutor will infringe my fair trial rights entrenched in section 35.3. Alternatively, in the event that the word title in section 106.1h of the CPA is interpreted narrowly to mean only formal statutory requirements for a prosecutor, meaning to include absence of independence and impartiality. In the further alternative, and then paragraph 7, in the further alternative, and as an independent basis, I'm advised that Mr. Downer should be removed as prosecutor because he lacks the independence and impartiality required by the Constitution. So he defines his case as a case directed at Mr. Downer because he lacks the independence and impartiality required for a fair trial. That was his peg on which he hung his case. Then the extensive evidence was filed. Mr. Downer and a range of other officials addressed Mr. Zuma's complaints. And then and at that stage, there's no suggestion of oral evidence. But then Mr. Zuma comes back and reply, and for the first time now says that he wants a referral to oral evidence. But look at what he wants to refer. He doesn't ask for an opportunity to adduce his own evidence by orally. On the contrary, what he demands when he speaks of oral evidence is an opportunity to cross-examine Mr. Downer and a variety of other state officials. And he does so again and again, if I may refer you in this regard to his reply. Obviously, let me say this, Mr. Zuma appreciates when he files his reply that he's not made a case, because there was a complete answer to all his complaints raised in his founding papers. And he's unable to refute Mr. Downer's evidence and those of the witnesses supporting him. And so it's a symptom of his recognition of his failure to make a case that he now resorts to a request for a referral to oral evidence. But look at what it is that he wants. Firstly, at page 4162, paragraph 14.
Give me a moment, please.
Certainly.
It's 4162.
Yes. Paragraph 14, where he says the following. This is now in reply. Secondly, a hearing on the plea requires an evidentiary hearing on two aspects. The first aspect requires a determination on whether, as a fact, Mr. Downer lacks the independence and impartiality to conduct a lawful prosecution, even though he can prove the formal qualifications. The second aspect arises from the outcome of the first and depends on the gravity of the deviation from the requirement of a lawful prosecution, which includes assessing the degree of prosecutorial misconduct and violations. So this is a general statement. Remember, this captures his entire complaint. So what he says here, I want oral evidence on my entire complaint. Matters, by the way, which have already been decided by the SCA in the Spite Taps case and by the full bench. But he then goes on over the page to be more specific. That's at still paragraph 14. This is paragraph 15 at 4163 in the third line. So I'll pick it up on the second line. I am advised that in that evidentiary hearing, I am entitled to cross-examine Mr. Downer or any NPA official on the criminal conduct or prosecutorial violations on which I contend that Downer lacks the necessary title to prosecute. I am advised to apply to the court to direct an evidentiary hearing on the question of title to prosecute to the extent that I contend for its wider constitutional interpretation. And then the last three lines of that paragraph, Mr. Downer must be removed as a prosecutor of my case on the basis that there is objective evidence that he lacks the rights or title assigned by the Constitution and the NPA Act. So he sticks to his attack on Mr. Downer as being insufficiently impartial and objective, and he says he wants an opportunity to cross-examine Mr. Downer on that broad issue. Nothing in particular, but on the issue generally. And then at page 4189, paragraph 68. where he says the following: no court has determined this issue by conducting an evidentiary hearing to determine the scope of political interference and whether such interference violated my right to a fair trial. Well, that was determined in scathing terms in the Spytest judgment, the SCA, and by the full bench. And then he says, I skipped 4 lines and I can then continue. The prosecutor must present the evidence of Messrs. Hofmeyr and Mshe of political meddling. So what he wants is for the NPA to call those people. It must at the same time present the evidence of Messrs. Nguka, McCarthy and Piccoli, persons who potentially committed criminal acts in my prosecution. It is clearly untenable for a prosecutor who has shown a tendency to cover up criminal wrongdoing involving political interference and the involvement of foreign spies in my prosecution. Paragraph 69, Mr. Downer is a witness in respect of the following key issues. 1, did he speak to persons in the media about the case? 2, did he know about Nguka's criminal interference in my prosecution? 3, did he know about Mr. McCarthy's criminal conduct? Those are the demands of a litigant who realizes that he's not made a case. He doesn't have an answer. And for that reason, he now says, but call them up so that I can cross-examine them, even though I have no evidence to contradict their innocent explanations. Then at 4193, paragraph 76, he says, the trial court is entitled to, paragraph 76, the third line. The trial court is entitled to and must conduct an evidentiary hearing on the issue of political and intelligence so that the evidence is tested through cross-examination rather than a bald denial as Mr. Downer does. What Mr. Downer denies is the NPA's own version, and for that reason, the issue cannot be resolved simply on the basis of the application, etc. Well, that accusation of political interference, that was the core issue in the spy tapes case. That was the core reason why Mr. Mshe withdrew the charges. That was the withdrawal that Mr. Zuma's counsel conceded in the SCA was an irrational decision. That was the same decision that the SCA in scathing terms held to have been irrational. These are the self-same complaints that the accused now wants us to revive. He doesn't offer any fresh evidence, but he says, although I have not been able to make a case, I want you to call up all of the NPA's witnesses so I can interrogate them. Then at page 4234, he turns in conclusion to what he calls the bottom line. Paragraph 212. Once it is accepted that, like all other accused persons in South Africa, I am entitled to raise any plea or defense which is competent in law, then the only steps which this honourable court is legally compelled to take are, and he lists them, and the second step which he demands is to examine merits of the plea, including any objections thereto by the state, if any. These papers speak to that issue. Well, that may be so, but that doesn't say anything about oral evidence. But then he says in 213, at the hearing of the application, I will seek an order that an evidentiary hearing be conducted on the issues relating to whether evidence of political and intelligence meddling has undermined the state's duty to conduct a fair and impartial hearing. I am advised that it is the trial court that must first purge the infirmities of political and intelligence meddling in my prosecution. Now look at that. We've now left Mr. Downer behind. In the final analysis, this plea has got nothing to do with Mr. Downer. But it is a demand that the court undertake an inquisitorial investigation of a conspiracy theory which has been thoroughly discredited again and again and again. That's the conspiracy theory on which the Mche decision was based. It is the decision which was scathingly dismissed by the SCA in the spy tapes case. It was the same accusation which Mr. Zuma's counsel conceded was an irrational decision. And the components of that complaint were again raised in the stay application, dismissed by the court. So this is not a demand for Mr. Zuma to go into the witness box. The one thing he doesn't say is that he wants to go into the witness box and he has evidence to give. In this hearing, you haven't even heard what evidence it is that Mr. Zuma offers to give. On the contrary, there is no offer to give evidence. There is a demand for an inquisitorial investigation by the court of the conspiracy theories of Mr. Zuma, which have been debunked again and again and again. This application is Stalingrad season 27, and that is all it is. The manifest overlap between this application and the earlier litigation has been illustrated by the table comparing the paragraphs in his current heads of argument with the paragraphs of his application for leave to appeal to the Constitutional Court against the full bench judgment. And if I may ask you to go to that table, it is Annexure AA12 to the NPA's answer to the application for a postponement. Because what matters is not only the quantum of overlap, but also the topics on which paragraphs were simply cut and paste from that application into his current heads of argument. You'll see that the table gives us the number of paragraphs, the comparison of the paragraphs that were cut and paste. And I can tell you that on my counting, it comes to 135 paragraphs in all. 135 paragraphs of his current heads of argument were simply lifted from his application for leave to appeal to the Constitutional Court. That's the quantum. But look at the topics described in the second column. Firstly, on the NPA's so-called unlawful decisions, on the NPA's evidence of political interference, on Downer's report on the prospects of a successful prosecution of Mr. Zuma, on the NPA has no title to prosecute in violation of the accused's right of access to court, which includes the right to a fair trial, the self-same point that's being raised in this case. Comparative approach on the issue of unreasonable delay. Clean hands doctrine. Downer has no title to abuse prosecutorial powers. On the doctrine of abuse of process. So all the core issues on which the accused now relies, and all the core issues on which he now demands an inquisitorial investigation, are the self-same issues which were decided against him by the full bench, and in respect of which he abandoned his application to the Constitutional Court. So that is what he wants. Now we submit with respect that this special plea is acceptable, and for that reason there is no need or justification for any oral hearing at all. And as I've explained earlier, by excipiable I mean that under section 106(1)H, the defense is that the prosecutor has no title to prosecute. We submit with respect that even if you accept the accused's evidence at face value, it still doesn't disclose that defense, that special defense, doesn't support that special defense. It is clear that when the section speaks of a title to prosecute, what it means is a legal power to undertake the particular prosecution. Now, that legal power may sometimes vest in a private prosecutor under Section 7 of the Criminal Procedure Act, or in a statutory prosecutor under Section 8 of the Criminal Procedure Act. Or it might sometimes be vested in the National Prosecuting Authority. But the title of the National Prosecuting Authority is beyond debate, because its authority to prosecute arises firstly under Section 179(2) of the Constitution. It provides that the prosecuting authority has the power to institute criminal proceedings on behalf of the state and to carry out any necessary functions incidental to instituting criminal proceedings. That's Section 179(2) of the Constitution. That provision is echoed in the NPA Act in Section 20, subsection 1. The power is contemplated in Section 179(2) and all other relevant sections of the Constitution to institute and conduct criminal proceedings on behalf of the state vests in the prosecuting authority and shall, for all purposes, be exercised on behalf of the Republic. So that the power to prosecute, the title to prosecute on behalf of the state, vests in the NPA. And it is for that reason, because the power of the NPA to prosecute is beyond debate, that our courts have held that when Section 106(1)H speaks of a challenge to the title of the prosecutor, it means in the case of a prosecution by the state, not the title of the NPA, but the title of the individual prosecutor. That is what the court held in Ndluli. The case is in our bundle, but if I may just give you the reference again, it's Ndluli v. Wilkin, 1991, 1 SA 297, the judgment of the Appellate Division, and the particular passage is at page 306. It is an Afrikaans judgment, but where His Lordship Mr. Justice Eksteen expressly held that when Section 106(1)H refers to the prosecutor, the title of the prosecutor, it means the individual prosecutor and not the NPA. So that in this case, the section would allow Mr. Zuma only to challenge the title of Mr. Downer and not the title of the NPA to prosecute. Now, Mr. Zuma's heads of argument argues to the contrary. He argues that it is open to him to challenge the title of the NPA. And more particularly in his heads of argument in paragraphs 62 and 63, he invokes paragraphs from Gardner and Lansdowne, quoted in Ndluli's case, to the effect that Section 106(1)H.
My Lord.
Yes. Yes, Mr. Impartial.
I'm sorry to interrupt my learned friend, but I just Yes, I'm sorry, my lord, to interrupt my learned friend, but I just want to make it clear that if my learned friend is now referring to the heads in the main argument, that I don't know why this is being allowed, my lord, because we refuse to deal with the merits of the plea issue. So if he wants to go on and repeat his heads when we have not argued the matter in chief, well, then he's free to do so. But that has got nothing to do with the postponement application. We're certainly not going to argue the trial proceedings today.
Yes, no,
until the postponement application has been determined.
I understand that, but I understood
if your lordship wants to hear it twice now and whenever it happens, well, that's your lordship's prerogative here.
Yes, no, it's not a case of hearing it twice, I think, Mr. Mpofu. I understood the submissions to be made in the context of what is to be challenged and on what can oral evidence be advanced.
No, but we're now debating the wherewithal of the section 1061H, which is the very thing that we're saying should be postponed. What's the point of that, my lord? Because that's now being argued by the respondent before the applicant has raised the issue. The postponement is exactly for that purpose. But as I say, for us, we just switch off because we're not going to be entertaining the plea itself today at all.
Very well. Okay. Noted. Thank you. Please proceed, Mr. Tringa.
Thank you, my lord. I think I made it clear, but let me just make it quite clear again. We oppose the postponement because we say the special defense can and should be determined on the papers as they stand. And it's for that reason that I seek to persuade you that the special defense is acceptable in the sense that it is not supported by the evidence on which it is based. In Mr. Zuma's heads of argument, paragraph 62 to 63, he invokes passages from Gardner and Lansdowne, quoted in Glooly, to the effect that section 106(1)H allows a defense that the state does not have title to prosecute. But that's not so. It is true that those paragraphs are quoted, but His Lordship Mr. Justice Extian quoted those views only to reject them. He did not endorse them at all. Mr. Zuma's heads of argument in paragraph 66 also argues that in Phillips v. Botha, His Lordship Mr. Justice Hoekstra held that section 106(1)H allows a plea of abuse of process. But that is also, with respect, not so. Phillips and Botha was a case about a private prosecutor, and the court there said that a private prosecutor does not have title to prosecute if, in fact, he purports to prosecute privately under Section 7, but in fact pursues an abusive process, an unauthorized process. That was a debt collection in that particular case. And then Mr. Zuma's heads frequently argue that the NPA's misconduct has disqualified it from prosecution. And then it says, and it therefore cannot mandate Mr. Downer to do so. You know, the repetitive and long arguments based on Mr. Nguka's decision, Mr. Nguka's announcement that although there was a prima facie case against Mr. Zuma, he decided not to prosecute him. That goes on and on and on, which has nothing to do with Mr. Downer at all. But they inverted in the sense that they argue that because the NPA has been guilty of misconduct, therefore it cannot lawfully mandate Mr. Downer to prosecute. But that with respect, firstly, the suggestion that the NPA acted unlawfully is refuted by the evidence, including that of Mr. Nguka. But in any event, it is a thinly disguised attack on the title of the NPA, which Mgluli has said is not the point. Let me deal specifically with Mr. Downer's title to prosecute. Because Mr. Downer deals with it in his answer at page 1455, paragraphs 4 and 5, where he says that he is a senior deputy DPP. He was appointed by the KZN DPP to prosecute on behalf of the state in all courts within her jurisdiction. And that gives him title to prosecute in this case under section 20 sub 4 of the NPA Act, because the NPA Act provides in 20 sub 4 that subject to the provisions of this Act, any deputy director shall, subject to the control and direction of the director concerned, exercise the powers, that's the prosecution powers, in respect of the area of jurisdiction for which he or she has been appointed. So that puts paid to any challenge to Mr. Downer's title to prosecute. Now, the attack they make on Mr. Downer, for what it is worth, is an attack on his independence and impartiality. And such an attack is a permissible attack, but not under section 106(1)(h). It's got nothing to do with Mr. Downer's title to prosecute, with his locus standi. And that was so held by the SCA in the case of Porritt. That is, I also think this case has been in our bundle, but can I just give you the reference again in case I'm mistaken? It's Porritt v. NDPP 2014 ZA SCA 168 21 October 2014, and more particularly paragraphs 7 and 8, because the attack on the prosecutor in that case by Mr. Porritt was an attack on the impartiality and independence of the prosecutor. And the SCA held that such an attack, whilst a legitimate attack open to an accused, is not an attack under section 106(1)(h). And it held that to be so, particularly in paragraph 7 and 8. If I may just read from 8. The appellants were unsuccessful in their invocation of the provisions of section 106(1)(h) to challenge the title of the prosecutors. The decision of the court below to remove the prosecutors was not based on their lack of title, but on a different basis, namely that there was an apprehension on the part of the appellants that the two prosecutors were biased. But counsel for the appellants submitted in this court that where a prosecution is found to be biased, his or her removal may be said to be based on his lack of title to prosecute. The appellants were therefore entitled to demand an acquittal in terms of section 104. That was the argument that was raised. The court said of that, in my view, that cannot be so. It was not necessary for the appellants to place reliance on section 106(1)(h) for their application for the removal of the prosecutor on the basis that they were biased. The appellants did not have to tender a plea in order to place that objection before the court. I conclude that the removal of the prosecutor was not grounded on a lack of title in section 106(1)(h) of the CPA. So even if there is a good attack on Mr. Downer's independence and impartiality, that attack is not an attack available to the accused under section 106(1)(h), and that attack would not support such a defense. And that was also, that same principle was upheld by the High Court in the very recent judgment of Musa. That's the judgment of His Lordship Mr. Justice Strydom. It is SV Musa 2021 ZAGP JHC 61, judgment handed down on 19 May 2021. It is in our supplementary bundle.
Yes, I have a copy, thanks.
At page 79. If I may just emphasize paragraphs 99 to 102 of that judgment, because the court there held that the prosecutor in that case had been guilty of very, very improper conduct to the prejudice of the accused, but held still that that did not go to title to prosecute. That was a breach of the accused's right to a fair trial, but it didn't go to title to prosecute. And in this regard, particularly in section 101, at the end of the paragraph, His Lordship says, if such a person institutes a prosecution for an ulterior purpose, that will constitute an abusive process, which will affect the title of the private prosecutor within the meaning of section 106(1)h. The same would apply to a private prosecutor that never complied with the criteria of section 7. In the case of accused, the court prosecutor and title to prosecute are not connected as such. The abuses of the court prosecutor did not affect the title to prosecute, which vests in the prosecutorial authority as represented by the DPP or deputy DPP. The accused has failed to show that what transpired in this matter, with reference to what Advocate Naidu, that's the prosecutor, with reference to what Advocate Naidu did, falls within the ambit of section 106(1)h. So this attack on Mr. Downer's independence and impartiality, whilst a relevant attack or a permissible attack, is not a section 106(1)h attack. What it is a rerun of complaints made in the spy tapes case, and more particularly in the stay application dismissed by the High Court. All of these complaints against Mr. Downer were there raised and dismissed. And there is, again, on the evidence, absolutely no evidence to substantiate any legitimate complaint against Mr. Downer. His explanations for his conduct stand uncontradicted. What he has against him are a range of conspiracy theories without any underlying evidence, and then this plea for a judicial inquisitorial inquiry into the legitimacy of his complaint. So we submit with respect that the special defense is excipiable in the sense that it is not supported by any of the evidence tendered in support of it, and for that reason should be dismissed without the hearing of oral evidence, because there's no point to hear the evidence if the high water mark would still not support the plea. But then we also submit in the alternative that there are in any event no material disputes of fact, and therefore no point in a referral to oral evidence. We've already made mention of the fact that Mr. Zuma does not identify disputes of fact on which he says he wants oral evidence. He fires a shotgun approach, which says, I might not have made a case, but I want the court to undertake a broad investigation into all my conspiracy theories. And in order to do that investigation, it wants Mr. Downer and all of the state witnesses to be called up for interrogation. Well, that is not what oral evidence is about. An accused doesn't have a right, without any foundation in fact, to demand that a series of state officials be called up for his interrogation and his attempt to make a case when none existed before. What does exist is conspiracy theories in abundance. There is lots of conspiracy theories. But each one of them falls foul of the fundamental differentiation our law makes between inference on the one hand and conjecture on the other. I don't need to tell your lordship about that distinction. It is well known, but let me just give you two recent and authoritative endorsements again of the principle that a clear distinction must be drawn between the two. They are, in the first place, a judgment of the SCA in Knoop, that's the Afrikaans KNOOP, v. Gupta. Not the Guptas we know, it's a different Gupta. 2021, Volume 3, SA 88, Judgment of the SCA, paragraph 19, where His Lordship Mr. Justice Wallace, for a unanimous court, reminded us of the principle that we have adopted from the English case of Caswell, which distinguished between inference and conjecture as follows. Inference must be carefully distinguished from conjecture or speculation. There can be no inference unless there are objective facts from which to infer other facts which it is sought to establish. But if there are no positive proved facts from which the inference can be made, the method of inference fails, and what is left is mere speculation or conjecture. That principle was also endorsed by the Constitutional Court in a case of Gavrick, that's G-A-V-R-I-C, Gavrick v. Refugee Status Determination Officer, 2019, Volume 1, SA 21, Judgment of the Constitutional Court, paragraph 115, and more particularly footnote 115. And we submit with respect that that is all there is. Conspiracy theory upon conspiracy theory. There is no evidence of any misconduct on the part of Mr. Downer. There are suggestions that a prosecutor is required to prosecute with punctual impartiality, but that is a description of the duties and functions of a prosecutor. Those duties and functions were addressed by the same judgment in the SCA and Porritt's case, and more particularly in Porritt, paragraph 13, and paragraph 13 through to 15. And I won't recite it here, but the point the court made, the obvious point the court made, is that the prosecutor is the representative of the state in an adversarial contest. And he is required in that capacity to vigorously pursue the state's case to the best of his ability. He does have a duty to do so properly and fairly to the accused, but it is his, not only is he permitted to be partial, he's required to be partial because he's required to advance the case for the one side in an adversarial process. So merely to suggest that Mr. Downer at times, for instance, advised that Mr. Zuma should be prosecuted because there is ample evidence of his guilt, is not to identify any impropriety.
But Mr. Drengo, would that affect his title to prosecute?
No,
or is it a separate ground to remove him?
No, it's a separate ground to remove him. So we submit, and insofar as their case is, their fundamental case is that Mr. Downer was impermissibly partial. Our answer is twofold. Firstly, that doesn't go to title at all. But we also submit you have not made a case of of unlawful partiality in any event, even if it were to go to title. So even if they are correct in their argument that you should interpret title more broadly to extend not only to formal title to prosecute, but also prosecutorial conduct, even if that argument, ill-founded as it might be, were to be accepted, Mr. Downer has in any event not been guilty of any misconduct at all. And we here, my Lord, just come back again. On those issues are the very stuff that the Spike Tapes case was based on, and that the application for a permanent stay in the full bench was based on. Those were the complaints that underpinned those two cases. Those complaints have been dismissed by those two courts. We submit with respect for good reason, and that this court should do the same. So, in conclusion, my Lord, there's no point to any oral evidence. The application, the special plea, special defense under 161H can and should be decided on the papers as they stand for three reasons. The first is that the evidence does not support the defense in that it doesn't go to title. The second is that there are in any event no material facts in dispute between the parties. And the third is that the self-same complaints have been dismissed again and again. So that there is no justification for any oral evidence, least of all for the freewheeling, wide judicial inquiry demanded by Mr. Zuma. And for that reason, there is no need for any oral evidence. Given that there is no need for any oral evidence, it is lawful and permissible for your Lordship to decide the case on this virtual platform today. If you were to hold against us that oral evidence is required, then we would accept that you can't decide the special defense today and that we would have to come back another day for oral evidence. But we submit that oral evidence is not necessary, and we ask for that reason, firstly, that you dismiss the application for a postponement, but secondly also that you dismiss the special defense raised under section 106(1)H. My Lord, subject to your Lordship's questions, those are our submissions.
Mr. Tringove, the last submission that you made, that I also dismissed the section 106(1)H defense. Well, that was really still the hearing that was being contemplated.
No, the matter was set down for hearing today. It is only the application for a postponement that then sought to defeat the hearing. But there's no reason for you to allow the application for a postponement to defeat the main item on the agenda for today, and that is the application for the determination of the special defense.
But Mr. Mpofu now addressed his comments to me on the application, the adjournment application or the postponement application.
Yeah.
He hasn't addressed any submissions on the merits of the section 106 and the interpretation of what is meant by title, whether it should have a more restrictive meaning or a wider meaning. I understood when you referred to that to advance the case that it is your contention, the state's contention, that oral evidence as a reason for a postponement shouldn't be countenanced because you say, well, it won't take the merits any further.
No, indeed, that is so, my lord. But the corollary is the moment you deny the postponement, well, then the main order of business today is the special defense. And that's why I submitted to you that you should refuse the postponement and deal with today's agenda, which is the special defense. My learned friend chooses not to address it, well, then that's his choice. But we insist that you proceed with the main order of business today and not allow yourself to be prevented from doing so merely because the other side have launched an ill-fated application for postponement that should be dismissed.
But shouldn't I firstly deal with that application for a postponement, and if you're correct, then dismiss it or refuse it, and then afford Mr. Mpofu still the opportunity to advance the argument that he wishes to advance in respect of the Section 106 1H plea?
Well, yes.
And the factual basis advanced in the affidavit, because as he interjected earlier, he hasn't addressed that issue.
Yeah, I don't object to him having a second chance, having chosen in the first place not to argue it. If he wants to argue it, let him argue it. But what he should not be allowed to do is to enforce a de facto postponement merely by arguing only his application for a postponement and nothing else. And with respect, your lordship may address the matter in one of two ways. You may either hear us on the postponement and decide it, and then invite us to address the merits, or your lordship may, and I would submit more conveniently, require both of us to argue both matters, both the postponement and the merits, because then you don't have to rule on the postponement straight away before going into the debates on the merits. So while I entirely accept that we're entirely in your hands, we submit that the most convenient and appropriate way is to require both sides to argue the postponement, but then also the merits of the special defense in case you refuse the postponement.
Hello?
Yes. No, the difficulty that I just have with that is that in fact, hello? That in fairness to...
Yeah, you will. Let me just...
Sorry, Mr. Mpofu. Can I just make my statement? That in fairness
I'm so sorry, my lord. I thought I was muted. Sorry. I thought I was muted. I'm sorry, my lord.
Yes. That in fairness to Mr. Mpofu, this started off, I think, at the outset when I said we're dealing with this question of the notice of application. And certainly I contemplated that would be dealt with, although I accept that matters such as a ground advance in support thereof, i.e. that is that Mr. Zuma complains that he cannot give oral evidence, that you would be entitled to show why such oral evidence would be irrelevant or unnecessary. But the application that's still before me is the notice of application for a declaratory order and then a postponement.
My lord, I'm in your lordship's hands, absolutely.
If I decide that firstly, and then thereafter, if the application for postponement is granted, then obviously we'll have to come back on another day to hear all the arguments in regard to the special plea. If it's refused, well, then we would enter the arguments on the papers on the special plea.
That would just mean that your lordship would have to take a decision before we move on to the main case.
Yeah.
But we're in your lordship's hands on that score.
Yes. Are those your submissions then? Thank you. You've concluded your argument.
Yes, I have. Thank you, my lord.
Thank you. Mr. Mpofu, do you want to start now, or do you want to take the long adjournment and then...
Yeah, well, my lord, the lordship Masuku will do the reply, but I just wanted, before your lordship adjourns, just to say that I've never seen anything less, so I don't know what's happening in this country. we are not going to address the merits of the application that Mr. Trengov says must be dismissed, because we are here for a postponement application. So my learned friend, Mr. Masuk, will address the postponement application and nothing to do with the 1061H application. Whether it's acceptable or whatever will be discussed when that application is being discussed. So we refrain actively. Mr. Zuma is only here present, as I said, present for the purposes of the postponement application, and he's not here for the purposes of the plea itself. And we have not consulted with him about it. We don't even know what he might want to say about it, my lord. So I just want to say, my lord, that the submission that Mr. Zuma is present is devoid of any legal merit. Your lordship will see that in subparagraph 3 of 159A, it says, any proceedings in terms of subsection 2 shall be regarded as having been held in the presence of the accused, if during the proceedings that person, and then it says, dealing with video link 159.3, my lord, 159 big A3. So it's only in those circumstances that the presence is deemed by the law. There's no similar provision in relation to the trial itself, which is the point we've been at pains to make. This has nothing to do with oral evidence. Whether oral evidence will be led or not, we are now in the trial proper. So the issue about oral evidence is secondary. I don't know why we've been listening to it for 2 hours, because that's not the issue.
Sorry, just refer me to the section again that you're relying on now.
159 bracket 3, my lord. 159 big A, sorry. 159 big A. 159 big A bracket 3. There it has a deeming presence in respect of postponements. If for a postponement there's an audio visual link, you are deemed to be present. The point I'm making is that there's no section like that in relation to the trial itself. It's only for postponement. So the suggestion that Mr. Zuma is present is absurd and has no foundation in law. And if and when the 1061H matter is being discussed, then he will be present if he consents to be present, or if he's able to talk to his lawyers and so on. For now, he's only present here for the postponement. But apart from, I just wanted to clarify that the past 2 hours has just been a waste of time. So Mr. Masuku will deal with the postponement issue only, not the 106.
He's going to deal with the reply.
With a reply on the 106, I'm sorry, not on the 106, but on the 168. This application is in terms of 168 of the Criminal Procedure Act, which is adjournments.
Yes.
And we'll deal with that application.
Shall we resume at 2 o'clock?
If your lordship would be inclined to take a shorter break, because we're not going to be long, we could. Well, 2 o'clock is fine, my lord.
Can we make it until 1:30? Will the adjournment until 1:30 be in order, Mr. Mpofu?
Yes, my lord. We would appreciate that, my lord. We didn't think we would still. Yeah.
Yes. Can I just, before we deal with that?
Yes, my lord. We'll be indebted to your lordship.
1:30. Let me just quickly determine. Mr. Roo, are you still there?
Sorry, yeah, breaking, my lord. If your lord kindly repeat.
No, sorry. I was asking whether Mr. Roo is still there. Are you having difficulty following, Mr. Mpofu? Is the interruption in the sound?
Yes. I
Right,
can hear you. Yes.
Yeah, let me just establish, Mr. Roo, you're not participating in this process, but obviously the application for a postponement, if granted, would cause a delay which could impact on Thales, the second accused. Is there anything you wish to say?
Yes, my lord, it is actually correct that we're not participating, as we said last time. I just need to put on record that we're ready to proceed. We've been ready for a long time, and that we are concerned about the time allocations we reserved ourselves for a certain period, as discussed with Mr. Downer, and whatever the outcome is, I just need to raise that and record that concern that we do not want to find ourselves in a situation where we have to go back to the court and try to arrange dates without continuing with the trial. We're just concerned about it. But we've kept open for 4 months, as discussed with Mr. Downer.
Yes. Anything else you wish to add? Is that it?
That's all. Thank you, my lord.
Thank you. We will then resume at 1:30, Mr. Mpofu. Mr. Mpofu, we will then resume at 1:30.
As court pleases, my lord.
Thank you. Yes, we will adjourn then.
Yes, my lord. Yes, my lord.
All seem to be back. Mr. Masuku, your reply?
Thank you, my lord. May I start by looking at the scope of today's proceedings?
Yes.
Which Mr. Mpofu has clearly explained. And they also come from your lordship's directive,
Yes.
which appears in MPT 4 in the founding affidavit. In that directive, your lordship says, having considered the responses received from the parties and having regard to the contents of Mr. Downer's letter addressed to me, dated 14 July 2021, recording what he was advised by the head of the Escort Correctional Facility, I hereby direct that the proceedings in the above trial, scheduled to commence on 19 July 2021, shall proceed virtually.
Yes.
And here is why we're here today.
Mm-hmm.
If a postponement is required, then a substantive application will be required to be brought.
Yes.
This is a postponement in accordance with the directive of the court. In other words, the scope of submissions that that can responsibly be met are submissions that are directed at whether or not it is consistent with the accused's constitutional rights in Section 35(3) of the Constitution to have the matter proceed virtually. And there is another related submission to that, is that a virtual hearing is an exception. It is a virtual hearing in criminal matters is an exception. In other words, it constitutes a limitation of the scope of rights that an accused person is entitled under Section 35. And therefore, it must be justified in terms of Section 36 of the Constitution. And that is very important, my lord, because you have to ask yourself with respect whether or not a directive that critical aspect of a plea that may well result in the acquittal of the accused is in fact heard in his physical absence. The arguments around whether or not he's physically present, I'm not going to deal with that. He's not here. He's not in court. We see him virtually, but he is not in court. So what your lordship has to then consider in evaluating the cogency of the postponement application is whether or not the applicant for the postponement has made out a case in relation to the rights that are a subject of the trial. In other words, has the applicant made out a case that, given the circumstances that have resulted in adopting this exceptional manner of hearing this case, which is by virtual, the very circumstances that have resulted in us, in your lordship, directing that a virtual hearing be the manner in which we proceed, which is the disruption in the court, the absence of the accused because he's incarcerated, and the fact that he has now filed a Section 108 plea in terms of which Section 108 notice in terms of which he would like oral evidence to be led in his plea. Now, those are not matters that ought to be decided that ought to be decided in this particular hearing. What has to be decided here is whether or not, in terms of Section 36, the less restrictive means to achieve the purpose of the trial, the purpose of the hearing of the plea, is more appropriate, and the less restrictive means is a postponement. And my lord, you have to ask yourself, in the arguments that were advanced by my learned friend for the NPA, Mr. Trencott, not once did he refer to the prejudice that the state would suffer if there is a 1 or 2 or 3 weeks postponement. Not one allegation I can recall him making in terms of which he said the administration of justice would be undermined if a postponement of 1 or 2 weeks is granted in order to ensure that the ideal constitutional conditions for conducting this particular trial are achieved.
Yes.
Not once. So would ask that in determining this application, confine yourself with respect to whether or not a case for a postponement has been made out. By reference to the rights that the applicant for postponement is asserting. My learned friend for Mr. Trengrove started off by reminding us although irrelevant, is tried to remind us, or rather reminded us, what the state's obligations are in relation to the prosecution of crime, not just corruption, but crime. That takes the matter nowhere. Because in so saying, he was not suggesting that a postponement of a week or 2 or 3, in fact, it would be inconsistent with that purpose of prosecuting crime by the state. He couldn't suggest that, because clearly that suggestion would be wrong. But in explaining what the duties of the state to prosecute corruption are, he did not refer, Your Lordship, to any provisions in the Constitution that govern how that prosecution must take place. The specific constitutional circumstances that are prescribed for the conduct for performing this particular function of prosecuting crime. And Your Lordship, I would suggest that Your Lordship refers to Section 7 of the Constitution, which binds not just the NPA, but binds the court as well. Section 7 of the Constitution, Section 7.2 of the Constitution, which says that the state must give effect, the state must respect, protect, promote, and fulfill the rights in the Bill of Rights. One must ask whether the NPA's conduct in opposing this postponement, which is not an opposition that appears to be reasonable, because this is not a postponement intended to frustrate the hearing of the conduct of the trial. We're already in the trial. The state is already prosecuting Mr. Zuma. He has already pleaded to the charges. What we need to do is to infuse in our procedural options the requirement of respect, of protecting and promoting and fulfilling the right in Section 35, in Section 35 of the Constitution. My Lord, I would urge that you also look at Section 8, which binds Your Lordship, which says that the Bill of Rights applies to all law and binds the legislature, the executive, and the judiciary. That means that Your Lordship, in making a deviation from the normal procedure in prosecutions, that they are bound to look at whether that deviation in terms of the procedure has the most important attribute, which is the protection of the rights of the accused, or the protection of the integrity of the prosecution itself, the constitutional integrity of the prosecution itself. And with respect, we would say that in the circumstances where Your Lordship has invited parties who wish to ask for a postponement to do so, and to set out the basis on which that postponement should be granted, if Your Lordship does go that far. It is expected that Your Lordship would then weigh the procedural option of postponing the application with due regard to the rights of the accused. Does a postponement give effect to the rights of the accused person, in the sense that the accused person would be tried in the constitutionally ideal or prescribed conditions, where he's present in court, where he's able to consult with his lawyers his lawyers, and where he is able to follow both the legal and the factual arguments, the basis on which an acquittal is being sought in this particular case. So it doesn't help to suggest, to find, to scramble, to find a constitutional basis on which a virtual hearing should be justified under these circumstances. An accused person says, I am not prejudiced if you postpone for 2 or 3 weeks. I'm not prejudiced. The state doesn't say he's prejudiced. The state does not say it is prejudiced. The state does not say the court is prejudiced. In fact, the court itself says invites parties who wish to have this matter postponed to actually bring an application for postponement. In those circumstances, the only question that the court must consider is to weigh a virtual hearing, its advantages and its disadvantages vis-a-vis a postponement. What are the advantages of a virtual hearing? As far as the advantages from listening to my learned friend, the advantages are that the matter is going to be expedited. In fact, if your lordship were to dismiss this application on the basis of what the NPA says, you'd be dismissed it on the basis really that this application for postponement is another attempt, which is also false, another attempt by the accused to delay the prosecution. This case has been on the national scene for over 15 years. And the greatest part of the delays have been the state's handling of the case. State is solely responsible for the 15 plus years of delay in bringing a lawful prosecution. We're here because the state has been told by the SCA that go and do the job, go and do your job properly, prosecute the man properly, and to try and then come up with the shortcuts of hearings in his absence, we're introducing further difficulties in terms of the conditions under which the accused person should be tried. The accused person is here, but he's not here in a courtroom where he's able to consult with his lawyers, where he's able to. I mean, this suggestion, maybe I should dismiss it very quickly. This suggestion that we can consult by telephone of some official of the correctional service is also very awkward for coming from a body like the NPA, because I mean they are not ideal circumstances for looking at your client as a lawyer and determining whether they're comfortable with the advice you're giving them, or just being in the presence of your client when you advise them on what it is that they need to understand about the trial that they are facing or the proceedings of the trial.
But the scope for taking instructions is obviously considerably less. One is dealing only with issues on paper, by way of exchange of affidavits.
Yes, I accept that, but here is the difference. Your lordship must not accept the state's approach of wishing to have this matter dealt with on paper, because we know that on paper their arguments are these issues have already been decided. So what they really want is the opportunity to come armed with civil judgments in civil courts, which have dealt with one or other aspect.
Yes, I understand that's going to be part of your argument, and I don't want to interrupt your argument. In the fullness of time, you'll contend that they're different, they're civil proceedings, etc. But I was raising it at the level of that inability to consult with your client is different where the matter is being argued on papers as opposed to a trial. This is the answer I was trying to give, my lord. Perhaps I was inelegant in giving the answer. Let me try again. And maybe I needed a bit of water to do that. But here is the answer that I'm trying to give to your lordship. Firstly, it is wrong that there are no disputes of fact. This case is heavily disputed. Mr. Downer's entire premise is that there is no prosecutorial misconduct, the nature of which has undermined the fair trial rights of Mr. Zuma. If we are right that there is enough evidence coming from the NPA itself that the nature of the misconduct, properly tried, the fair trial rights have been violated, we would be entitled to an acquittal. We would be entitled to have the court say
NPA, the evidence that I have here is so bad, and the evidence you have, my lord, just on the papers, is such that that should horrify any accused person completely. So,
I think the point that is,
my lord, I would really, I do want to make my submissions on the question that you asked me, which is whether or not there is a problem with the consultation. The applicant for a postponement is entitled to follow the legal arguments that are made in court, to follow the legal arguments not just virtually, to be able at an instant to ask the lawyers a particular question relating to an argument being made. These arguments on paper are not argued. These are not legal arguments only. The arguments that that contain facts that are disputed, heavily disputed facts. To try and strip things and say, well, he's entitled only to hear virtually legal arguments in a trial is to suggest that where legal arguments are being made with the potency of getting an acquittal on the basis of those legal arguments, he's not supposed to be there. With respect, that would not be correct. He's entitled to be present in court to follow the arguments that are being made, whether they're factual arguments or legal arguments, whether they're on paper or they are not on paper. He is entitled to sit with his lawyers to follow what is going on in a courtroom. He is also, my lord, with respect, entitled to watch the bench to see how the court is responding to the various arguments that are being made and to make his own assessment of where the case may be going. Like, for example, when a court says to counsel, with respect, that argument is absurd, right? And I'm not saying that's what your lord should be saying, but I'm just saying in the engagement between counsel and the bench, the court is entitled to test the propositions of counsel by putting strong views about a particular position. An accused person is entitled to watch, not through TVs and computer screens, to look the bench in the eye, as they would put it, to look and see where that bench is leaning towards. Based on it, to say to his counsel, listen, I don't think he's going that direction. Can you make that submission that I told you about earlier on when we consulted? There and there. Right now, if you wanted to give me an instruction to say abandon this application, we would have to stop this entire proceeding in order to do that. That's not the ideal constitutional framework in terms of which accused persons in South Africa are tried or elsewhere in the world. So I would say that there's also another reason, my lord, why you need to reevaluate your directive and order a postponement. It is because we are aware, and this was a submission made or a view expressed by the NPA regarding the conduct, bringing witnesses virtually to testify against the applicant. The applicant in this postponement knows that. He knows that there is an attempt by the NPA to bring witnesses virtually. And that application will come at some point during the hearing, when the overseas witnesses need to come here and there's corona and there are problems. They are going to be coming back to your lordship to say, we need this witness to hear this, to give this evidence orally. That is a problem. And if your lordship allows the virtual hearing now, why should we not allow a virtual hearing to be conducted in terms of the whole trial? The whole trial can be done virtually.
No, every witness and every instance will have to be dealt with separately on its merits.
Yes, but we know.
There's not going to be. You can accept, Mr. Masuku, that if a virtual hearing is allowed at one point, then it doesn't necessarily mean it's going to be followed throughout.
Yes, I accept that, but I'm just saying that your lordship would have created a precedence through a directive that suggests that it is okay to conduct a trial without the rigorous requirements that are set out in the Constitution. And lordship actually raises that in the first letter, where lordship invites us to make submissions. It's acutely aware of the baseline requirements for conducting a trial. And your lordship says, no, we are faced with circumstances that may require us to be creative. But when we are being creative, we have to be creative and lean towards protecting the rights of the accused person. The state will not suffer any prejudice. Mr. Downer's steam of wanting to prosecute this case will not wane because there's a 3 months postponement, or sorry, a 3-week postponement of this case. The NPA is and when I say his team, I don't mean to be vicious, but I do mean that his determination, and you can see that he's the one filing affidavits, even in this particular postponement application. He really wants to prosecute this case. And I don't understand why that cannot be done after 3 weeks when the matter is postponed. Why that arguments cannot be made after 3 weeks. So we're saying, Your Lordship, consider the scope of your ruling in terms of the directive you gave. Evaluate the state's submission relating to the actual plea itself, in terms of which you are now being asked to dismiss the plea, to dismiss the application to have oral evidence led, and basically to decide against to decide the issues of the plea, because that is not the scope of the directive that Your Lordship gave. Your directive was merely on the postponement itself.
Sorry, on the postponement itself?
Yes, the directive was that we should, if anybody wants a postponement, that should be filed. That should be provided on a substantive application. That's what we're about here.
But that was now for a postponement of the hearing that would take place virtually.
Yes. So Your Lordship interposed that procedural, that determination of a hearing on the merits by suggesting that anybody who wanted a postponement could do so. And by just reading through that meant that you would not determine whether or not the plea is good or bad.
Yes,
and that's why
if the postponement is granted.
If the postponement is granted, well, if the postponement is granted, but it obviously meant that Your Lordship would accept that a substantive application of a postponement, particularly in the terms that we have set out, would be a postponement in terms of which serious submissions would be made relating to the constitutional implications of the directive to hear this matter virtually. And we have raised that aspect of whether or not the directive does meet the Section 36 requirement. Yes. And we say it doesn't, because it is a deviation from the normal. It does not meet the requirements of Section 36, because Your Lordship will know from the arguments made on behalf of Mr. Zuma that in terms of Section 36, the limitation must be reasonable and justified in an open and democratic society based on human dignity. There is no dignity in asking Mr. Zuma to confer with his lawyers via cell phones of other people. Where is the privacy of the consultations there? There's no dignity at all. There is no equality that is advanced here, because this procedural today it's doubtful that in the Pietermaritzburg court any criminal trials are running, because we are aware of a directive by the judge president, in terms of which motion and some criminal trials in P1, 2, and 3 are not running today. So we're saying that the equality. The equality aspect is implicated. We're not necessarily saying that you have treated me unequally. We're simply saying that you have to say to yourself, does my directive place Mr. Zuma in a different legal or procedural platform? And it does. It suggests that it is okay when it's simple legal arguments or arguments on paper for him to be absent, and that can't be right. Because his rights are as good as when he is as good when arguments are being made on paper as they are when there is oral evidence. That distinction doesn't really justify the deviation from the norm. And besides, Your Lordship is consistent with how other courts, including the Chief Justice, has basically reacted to the disturbances that have occurred. They've said, well, if you are going to adopt any procedural mechanisms for the hearing of any parties, those must never deviate from the core rights the integrity of those hearings must never be compromised because of the issues. So a postponement would simply mean that the hearing of the plea is postponed for a date where parties can assess whether or not the disturbances are such that another procedure can be adopted. And this is not new, my lord, because you will know from the history of this case that parties have in fact agreed to postpone matters because of coronavirus. They've agreed to have the matters postponed, particularly the holding dates being moved from date 1 to date 2, and the reason being given being that the pandemic is a problem. In fact, I can recall that the state itself at some point requested a postponement on the basis that it wasn't clear whether their witnesses who are coming from overseas would be able to come during the pandemic period. And so the matter would be moved forward so that we allow the situation to abate so as to conduct an ideal trial governed by the prescribed constitutional framework. And of course, the taking into account all relevant factors, the nature of the right that is involved. The nature of the rights involved is a right to a fair trial. The purpose of the limitation. The purpose of the limitation is to determine. I don't want to give your lordship the rationale behind the virtual hearing. The rationale behind the virtual hearing was that there are disturbances and that Mr. Zuma is not present, and that there is a pandemic. All three are good, except that there is except that one must look at the other factors, which is the nature and extent of the limitation. The limitation is we can't consult with Mr. Zuma. We can't. The limitation is that he will have to follow the trial or on his plea that may well acquit him virtually. And the difficulties that are the physical barriers that are placed by this virtual hearing are real. And I think the court accepts in its deliberation on whether a virtual hearing or postponement is appropriate route. The relationship between the limitation and its purpose. What here, my lord, one has to look at is you have got two options. The one option is to have the matter here virtually. The other is to hear the matter postponed. Which one will not give any problems in terms of the integrity or the potential constitutional complaints that may arise out of this particular aspect? If there was no coronavirus, if there was no disturbance to the court, if Mr. Zuma was able to physically be in court, there would be absolutely no complaint. What this directive does is that it raises in an already heightened trial a procedural ruling that does not create an ideal constitutional environment for a fair trial hearing. Mr. Zuma would be justified to say that, look at this now. I'm advised by my lawyers that I should be in court hearing my plea and listening to what they are saying about the facts that underpin that plea. But I'm being forced to hear that while I'm in prison. There's so much agency that Mr. Downer and the NPA sees. There's so much agency to have this matter heard. It's 15 years down the line. A 3 months delay takes the matter no further. And there are no risks whatsoever in having this matter postponed. There's no prejudice whatsoever in having this matter postponed. In fact, a postponement would be a justified limitation of this right to have a matter heard expeditiously. Because of reasons of his absence, the coronavirus and the disturbances, a postponement, as other cases have been postponed, other cases in the same court have been postponed, would be justified in the circumstances. And we would urge your lordship to reevaluate the directive and to order that a postponement be granted.
You're not pursuing the paragraph 1 declaration of rights there?
No, we are pursuing it vigorously, because, my lord, it's now clear from the arguments advanced by the state, because the state says there is no constitutional violation when a virtual hearing is directed under these circumstances. In other words, when there is a disturbance, when there is a pandemic, and when the accused person is absent, there is no constitutional violation in having the matter heard virtually. That's what the state is saying.
I understand that, but can I decide that?
Yes, you have to decide that, my lord, because I'm not even going to. My learned leader has already said to your lordship that don't worry about the fact that you are reconsidering your own directive.
No. It's in form. I hear what you say about reconsidering a directive. It's different to issuing a declaration of rights, though.
Yes, because our opponents, the people who are supposed to conduct the trial, are putting doubts around the rights that are implicated in the directive. And we want that made very clear that today, in future, a virtual hearing will only be an exception, justified by circumstances that are pleaded at that particular point. It is not right for the state, particularly the NPA, to want to treat Mr. Zuma differently. They've been doing that for too long. They must apply the law as they are commanded to do so in terms of the act. This passionate, this zealous pursuit for Mr. Zuma at all costs by bending rules and cutting corners is not right. Let's just have a fair trial. Let's have him in court. Let's have everybody there. Let's argue the case there. Mr. Trenkov can't in good conscience say that it is the platform today to decide the plea, even for purposes of a postponement, because as I understand his argument, he's suggesting that the plea is so meritless that a postponement has no value. That's his view. He has got a mandate that he carries. We've got a mandate to carry. Your lordship must hold the fort, must hold the two reins and hold the ring so that we're able to fight properly on the plea. And for that, we will debate whether or not we're entitled to cross-examine the averments made on affidavits. We'll have a debate about that later. Today, what your lordship needs to decide is whether or not you should reissue a directive in terms of which this matter is postponed to a future date. And you would be in good company, my lord, if you did so, because you will know that next door to your courtroom are matters that have already been postponed for the same reasons that this matter is being heard virtually. Even civil matters are postponed. They are not being heard because the judge president and others have decided that it's ideal for matters to be heard when there are no disruptions, when there are no potential disruptions to the running of the courtroom. So would say a postponement would would give effect to the rights of Mr. Zuma in Section 35(3). A postponement would be consistent with the proper administration of justice. A postponement would enable this matter to be tried on the merits, and no interlocutory applications ought to be easily provoked on either side. So this idea of wanting to cut loose this privilege invited by the court to seek for a postponement, to argue that the plea should be dismissed is with respect not a responsible response to your lordship's directive. Your lordship was quite clear. We're only here for a postponement, and your lordship cannot make an order dismissing the plea or make an order that the plea will go on oral evidence. That will come in its future time. Today, all we're asking is that create the ideal conditions which your Lordship is aware of from the writings you have conveyed to us and which your Lordship has routinely practiced under. Just let's be normal with Mr. Zuma for a while and create no exceptions for him. That is consistent with what our Constitution says in Section 9 of the Constitution, the equality provision. My Lord, I am alone here in Cape Town. I am led by someone who is in Johannesburg. I have no idea what he wants me to say as a closing remark. I've got juniors who are both in Johannesburg and in Durban. Now, this is the difficulty. Can I take 2 minutes to find out what my team has to say I should add, including the possibility of asking Mr. Zuma whether or not there's anything I have left which might persuade your Lordship that a postponement is absolutely necessary to take.
Yes, Mr. Masuku, it's now 2:05. Oh, sorry, a bit more. How much time do you need?
Can we take maybe 10 minutes?
Yes, certainly. Shall we say 20 past, 25 past?
I'll take the more, 25 past.
25 past. All right.
Yes.
We'll resume at 25 past.
Thank you, my Lord.
Thank you, my lord. We are.
Thank you. And then Mr. Zuma. Mr. Zuma.
Yes, I'm around.
Thank you very much. You can hear us clearly. Yes.
Yes,
Any further questions, Mr. Masuku, or you?
Yes. No. My leader says he's happy with what I've said, but there are just one or two things that I need to deal with.
Yes.
The first one relates to the.
Yeah. Sorry.
The first one relates to the reference to the De Beers case.
Yes.
My lord, you will see that the De Beers case is distinguishable to what is happening here. The question is never, the question that your lordship must answer is not whether or not virtual hearings are permissible in certain circumstances or not. The question is quite different. The question is whether or not the applicant in the postponement has made out a case for the matter to be postponed. We're not here trying to impugn the legality or the constitutionality of a virtual hearing, only to the extent that the declaratory order is sought. But this is not a frontal attack on the dispensation of virtual hearings.
Okay, so if I understand correctly, you're saying that there could be a virtual hearing ordered, yeah? It wouldn't be improper, but you're saying on the facts at present, it shouldn't have been granted.
Yeah, what we're saying, in a trial environment, a virtual hearing should not be granted. And because there is now a dispute with the NPA on that particular dispensation of conducting trials via virtual hearings, it does implicate constitutional rights for which a declaratory order is important. Because they have put it in dispute. They've put it in dispute whether or not there are circumstances. In fact, according to them, this could just be the trial. So we're saying that the De Beers case is not a case that we need to it's distinguishable from the facts of this case. This was an appeal in a court of appeal. It takes the matter no further than just articulating the obvious that in certain circumstances a virtual hearing may be ordered and has been ordered in the past. And then similarly with Regulation 14 that my learned friend referred to, Regulation 14 in its other means should never be extended to mean that a trial can be conducted through a virtual hearing.
When you say trial, you mean a trial with viva voce evidence?
Yes, I mean a trial with viva voce evidence.
Yes. But an aspect of a trial that doesn't involve viva voce.
Sorry, my lord. Perhaps I should defer to my leader who is watching, and I see he's shaking his head. So maybe I'm doing something that he doesn't like. Can I perhaps stand down and let him?
No, he says he's shaking his head.
No, my lord, I'm happy. I just want to say what Mr. Masuku is referring to was a criminal trial, not just any trial.
Yes. All right. Okay. There we go, Mr. Masuku. Are those your submissions?
No, the last one, my lord.
I think you still have one more to deal with. Okay.
The NPA's opposition to this postponement is of grave concern for how this matter has always been dealt with. In the past, as I've said, there has been an attempt to mutually accommodate each other where postponements were necessary. Postponements has been granted by agreement between parties. And it's quite telling that when Mr. Zuma is incarcerated, that the state would insist that a plea that may result in his acquittal should in fact be debated in his absence, in his physical absence, outside the courtroom, because it favors the state. I do no more than conclude by referring to, in dealing with the argument around the issue of the NPA we deserve, the NPA we must have, the NPA that the Constitution says we must have. It is an NPA that shall serve, in terms of Section 32, that shall serve impartially and exercise and carry out or perform his or her powers, duties, and functions in good faith and without fear, favor, or prejudice, and subject only to the Constitution and the law. What we hear today, that a postponement would, for some reason, the postponement does not violate the rights of Mr. Zuma, but for some reason, the state is insistent that the matter can proceed virtually. Perhaps we should consider virtual imprisonment. And so Mr. Zuma would not necessarily have to be in prison physically in a prison, but virtually imprisoned.
Yeah, Mr. Masuku, either case is made out for the postponement or it isn't. Concerns about a particular attitude, I don't think really at the end of the day carry the day, do they?
No, they do, because my lord, you listen to Mr. Trangrove make arguments about how bad the plea is, and make arguments about that it should be dismissed. And I know that's for not, it's completely outside the terms of your directive. But you had submissions that were completely irrelevant for this purpose. And I'm suggesting that the only reason why those submissions were made, and you will see that there's a constant idea of churning out material that will suggest that Mr. Zuma is wasting the court's time, wasting the NPA's time. He should not be complaining about his fair trial rights. That will not happen. Mr. Zuma is entitled to the protection of the Constitution. It doesn't matter what the NPA believes about those rights. He will insist when they are violated. He will come to your lordship and he will say, please give me a postponement because what is about to happen will violate my rights. And a lot of people are now asking, why is this trial being conducted virtually when even civil matters are postponed to the 26th of July? What is the urgency? What is this drive that the NPA insists on wanting this particular plea to be disposed of out of hand? They must be patient. They've tried their best for 15 years, and this matter will come before your lordship. The plea will be argued, and Mr. Wim Troost no doubt will make those arguments that he made today. But today was not the time and the opportunity to make those arguments, because those were not covered in the scope of your directive.
Yes, I saw them having a relevance to what is alleged in one part of the founding papers. But I've heard your submission, so let's just, I think we don't have to take it any further.
No. It would be nice, my lord, if I heard you say something like, no, Mr. Masuku, I hear your point, and just leave it there. Because what Mr. Wim Troost said was to ask you to dismiss the plea. You say dismiss the plea, dismiss the application to apply for oral evidence.
Mr. Masuku, I'm dealing with this matter, if it hasn't become apparent now, on the basis of an application for a postponement.
No, it is apparent, my lord. I'm not impugning your lordship's. No,
I just want to. No, I'm not suggesting you are. I just wanted to give you that assurance.
I'll take that to the bank, my lord. my lord, those are the submissions that we make. We ask for a declaratory order. We also ask that the matter be postponed and appropriate arrangements made for a constitutionally acceptable framework under which Mr. Zuma's trial can be conducted.
The postponement that you're asking for, is that a week?
I would suggest 3 weeks. 3 weeks would be appropriate, my lord.
And is that going to suit all counsel?
My lord, perhaps one of the directives you could make is that counsel then engage virtually to determine in the third week which dates are suitable for the further conduct of the trial. Because who knows, my lord? I mean, I know that the state suggests that the disturbances are somehow linked to Mr. Zuma's arrest or incarceration in their founding affidavit. But what happens if, for example, next week there is another disturbance, and there is a need for us to come back to you and to say, my lord, we've got this problem, or the pandemic itself comes heavy in the courtrooms of the.
Well, what you say is that the directive might very well still be correct, depending on the circumstances.
Which directive, my lord?
The one I issued, that it should proceed by way of a virtual hearing.
No.
If conditions should become worse.
No, because then your lordship must engage with whether or not it's appropriate to conduct a virtual hearing of the trial itself.
Yes, no, but then it'll have to be determined in the prevailing facts at that point.
Yes, certainly, because we're here because of the prevailing facts.
The terms in which it has been issued, it might be fine.
No. I've made my submissions on that aspect, my lord. I'm sure that your lordship would accept that. That's not what I'm saying. Or what I'm saying is that there is if you do grant a postponement, it does accord with the rights for which the postponement is granted, and it is.
Well, maybe I should then just fix a date if I am so disposed.
Well, if you do fix a date, obviously, if there should be a reason why that date fixed can't be complied with, we will come back to you and ask for. We really don't want to a situation where your lordship is not in control of the process going forward. If your lordship feels that a date should be fixed, then your lordship must fix a date. If your lordship feels that a better way is for counsel to engage with each other so that we come with an agreement on the dates, then your lordship could direct that. And if we can't come with a date, your lordship can then propose a date.
Yes, the matter was adjourned until today's date, for the trial to continue, wasn't it?
No, we've met the submissions, my lord. I can't. I can see where your lordship is going, and I particularly want to say that we accept that the trial was meant to continue today. There were circumstances that intervened for which your lordship addressed us on, and your lordship invited submissions. Your lordship issued directives. There was no need to issue directives.
What I'm trying to clarify, it was set down from now for the next couple of weeks, at least for the session.
No, the conditions won't change tomorrow, my lord. If the idea is to postpone it tomorrow.
I know that, but I'm just asking, was it not set down from today for the rest of the session?
It was.
Yes. Thank you. Yes. Anything further, Mr. Masuku?
Nothing further, my lord. Those would be our submissions.
Thank you. Yes. Can anybody still hear?
Yes, we are, my lord.
Yes,
thank you. This matter is adjourned then until tomorrow. I shall endeavour to give my ruling tomorrow at 10 o'clock. I'm not promising it will be with reasons, but probably with reasons to follow later. But I'll give my ruling tomorrow at 10.
Lord, may I just put on record that for your benefit and of my learned friends, that I am instructed that the prisons have made facilities available to Mr. Zuma to consult with his counsel in one of three ways, either by personal visit, unlimited personal visit, or unlimited use of a Zoom virtual platform, or unlimited use of a telephone.
Thank you. Thank you. We will meet tomorrow then at 10 o'clock.
Thank you, my lord.
Adjourn until.
Thank you, my lord.